Donald Trump's co-defendants are now battling for classified materials in the Florida case. Trump is also battling for the classified documents, but there's a little interesting rub here because Trump was the former president and these other co-defendants were not. Why would they get access to the classified documents? Or why would they get access to maybe not the documents, but at least information about what Jack Smith is doing with the documents or how these documents are being communicated about behind closed doors in the courtroom chambers? And Trump is filing similar motions to get access to these things. But let's take a look at this one because it goes to the obstruction element of what Jack Smith is alleging. Remember, Joe Biden had classified documents. Many other people have had classified documents, including Hillary, who deleted them like with a cloth. And there are concerns about that, obviously. But what about Walt and Carlos? Why would they have access to these materials? Well, because Jack Smith says that they obstructed the retrieval of those documents, right? They had possession at some point in time over the documents themselves. This is something that is curious filed out of the Southern District of Florida. The case is United States of America versus Walt and Carlos. But this is going to sort of implicate Trump because they're saying that Trump basically gave these guys permission illegally to go and access the documents, right? You see how this can layer onto itself. So I think that this motion is probably filed in conjunction with Trump and his defense team because they're filing something similar. But let's take a look at what this argument is. It says here, defendants Walt and Carlos, by their lawyers, they hereby respectfully request that this court limit, and this is the same concern in the Trump case, the ex parte nature of Jack Smith's filings, right? Jack Smith keeps going outside of the defense. They say now at the outset here, Mr. Nauta and Oliviera, they agree with former President Trump, kind of safety in numbers here, that a motion to SIPA is a critical juncture when the government asks the court to endorse the withholding of discoverable material by determining whether the material is relevant or helpful to the defense, right? So they get to decide what evidence the defense gets under the name of national security. Now, in effect, because SIPA creates no new rights or limits on discovery of a specific area of classified information, prosecutors filing a motion pursuant to this provision are seeking permission to withhold Brady material, okay, material that might exonerate you. They're just trying to say, oh, it's not classified. And this is a pernicious tactic that they use, right? Everything's classified, so you can't even see the materials against you. Now, these motions require the court to stand in the defendant's shoes. And we've got a very different judge here. In Chutkan's case, she says, oh no, Trump's a monster maniac insurrectionist. And so all this national security stuff, he doesn't need to see it. But this is Judge Cannon. She's in a different situation. It says, these motions require the court to stand in the defense's shoes, to predict defenses that the defendant has not yet presented and is entitled to develop and modify until the case is submitted to the jury for deliberations, and to protect important defense rights to exculpatory information relevant to trial and sentencing. In other words, we need this stuff. Defense rights. Now, accordingly, only, quote, special circumstances may justify removing SIPA from the traditional adversarial system and turning to the applicable statute. Here's what it says. The court may, upon a sufficient showing, may authorize the United States to even delete specific items of classified information from documents made available to the defense. Okay, there's a provision of the law that allows the government to just delete stuff from the defense and substitute a summary of the information for the materials and the relevant facts that the government thinks is appropriate. Now, the court may permit the United States to make such a request for such authorization in the form of a written statement. So Jack Smith's prosecutors, under the federal government laws, we already know, the intelligence agencies have a strong anti-Trump bias. We've seen that in 2016. We've seen that in 2020 with the CIA and the FBI censoring social media and creating fake Russia hack cover stories. So now we're asking the DOJ, in sort of collusion with these intelligence agencies, since they're the entities that manage the classified documents, right? They govern all of that. So the DOJ, which is anti-Trump, appointed by Joe Biden's Merrick Garland, Jack Smith to go after him, is now colluding with the same FBI and the same CIA that rigged everything against him in the first two elections and the first one attempted. So now they can just delete evidence and keep it from Trump and the defense. So here, now we're saying the court may permit the United States to make this authorization, and this authority is derived from different rules. Now, the permissiveness is consistent with a congressional admonishment that we're supposed to clarify what these rules mean. And they say specifically, Your Honor, Judge Cannon, not Judge Chutkan, ex parte is permissive. And ex parte means that Jack Smith and Jay Bratt, who's down in Florida, they are sending documents outside of the defense. They're bypassing the defense, sending it directly to the judge and having Judge Cannon make rulings on them. They're saying it's only permissive. You're not required to do this. Here, the unique facts and circumstances in this case, Judge Cannon, they warrant the court court rejecting the special counsel's request that its SEPA 4 hearing motion be heard ex parte. First, our defendants in this action, we're not accused terrorists. We're not unlikely to obtain security clearances necessary to review this information. And so these rules don't apply to us. In fact, to the contrary, both President Trump and Mr. Nauta had unrestricted access to all the classified information at issue. And you might have some concerns about that, because did Walt Nauta have clarity, have classification authority to go look at those things? Let's see. The government asks too much, however, when it expects this court to exclude Trump's lawyers and Walt's lawyers from even reviewing these statements. Says lawyers have security clearances, and there is every reason to think that the counsel can be trusted with this sensitive information. And second, the nature of the classified information at issue in this case requires that it be accessible by both the defendants and their counsel. Why? Because the indictment itself alleges that the wrongful retention of the documents and the conspiracies to obstruct the special counsel into the retention, it's part of the crime. You are charging our clients with obstruction and wrongful retention of documents. So we need to see those documents. Like, that's the evidence, so we can review it. Now, you are literally charging them with that and then saying they can't see the evidence against them, so we need to see it. Accordingly, the individuals best positioned to inform the defense counsel of the nature and the circumstances about these documents and about these conspiracies are Trump and his closest advisor, Nauta. Like, they need to be able to see the material so that they can opine on them. And they're trying to delete the evidence and keep it away from the defense. Now, in the alternative, they say, were the court to permit any ex parte review of their submission, if you're going to look at their submissions outside of us, only two aspects of the same warrant this review. First, the district court must determine what materials in question are in fact discoverable. Here, in potentially the most consequential test of the balancing test, right, the government needs to balance its interests. The government says, my national security secrets, we can't give you anything or else America will die. And the defense says, we need everything because we have a right to a fair trial. And they say here that this court should agree that there is an adversarial system championed by our founders. And so you should limit Jack Smith from keeping this stuff hidden under dark of night. Stop him from seeking to withhold this stuff from defense counsel. And second, Judge Cannon, it follows that if the materials are discoverable, if we can get access to that stuff, the court must then confirm that they are in fact classified. If they're not classified, then the rules say that the court is not authorized to delete or summarize the materials in question. We want it. Put simply, if the material is not actually classified under the court's determinations, then SEPA does not apply. And so to meet its obligation of demonstrating that the materials in question are in fact classified, the government will submit explanations. But here again, neither the defense team nor any defendant have any need to know the classified information that the government relied upon are in fact classified. And while it remains the position of these defendants that the court would benefit from the typical adversarial system that we like in America, should it decide to consider any materials ex parte, that review again should be limited. So if you're going to do what Jack Smith wants, make it very limited. Once the court concludes that the materials that the government tries to withhold are discoverable and that they are in fact classified, any privilege of the government applicable to these materials must give way to the defense's right to a fair trial. Can't hide evidence from us. We need to have it in order to prepare our case. Continuing saying, although this observation of Congress is broad, the Second Circuit has reasoned that what was intended by Congress. There's a presumption in the favor of the government's privilege. It's overcome by a district court's finding and a lot of case law here. And so even if this court were to conclude, despite a determination that the materials that they seek to delete are discoverable, they say the lawyers may not participate. If they say the lawyers may not participate, we should be able to participate in an adversarial challenge to their assertions. Again, ex parte communications are problematic. Let us at least respond to it. So give us what we want, but if not, at least let us be a part of the conversation. For the foregoing reasons, we ask now that the court respectfully order the submissions that they're sending to you, Judge. Like, we can see they're sending these things to you. Please disclose it to the defense. Signed by Walt and Carlos Oliviera's attorneys, seen here Stanley Woodward, Sasha Dayden, and Larry Donald Morrell, amongst others. All sending this in to Judge Cannon in the Southern District of Florida, West Palm Beach Division, demanding access to those classified documents, and we'll see if they get them. Now, this is Psaki and Schiff. Schiff, as we know, lied to us about a lot of classified documents, said, I got all these classified documents, lied through his teeth to America about it. But he showed up on her show on MSNBC called Inside Jen Psaki, and they're issuing new warnings about the threat. Here is Jen.
I wanted to start with some of what I just went through, because clearly what Trump did this weekend, accusing Joe Biden burden of being anti-democratic. I see some parallels here with what the Kremlin has done in the past, their tactic of projecting what they are doing onto their opponent. Do you?
Absolutely. There's real method to Donald Trump's madness, and it's not a playbook that he created. It's one that has been used, I think, by autocrats the world over and for a long time, and that is accuse your opponents of what you do. You know, Donald Trump's argument is really not that he's not corrupt or that he's not a liar. Rather, his argument is everyone is corrupt, everyone are liars, but I'm your crook, I'm your liar. You should be with me. And it's not just Donald Trump using this playbook, it's also Republicans in Congress. Donald Trump gets impeached on a legitimate basis twice. So they're going to impeach Joe Biden illegitimately. And why? To dilute the stain, to accuse Joe Biden of the same kind of misconduct that Donald Trump committed, when there is obviously no misconduct in the case of Joe Biden, but rather an effort by Republicans in Congress to muddy the waters, to dilute the stain of what Donald Trump went through. You see it in, you know, people like Elise Stefanik accusing Nancy Pelosi of being an authoritarian or an autocrat. It's absurd.
They are literally, did you hear him say that? Saying accusing Pelosi of being an authoritarian? Look, their chyron at the bottom of MSNBC is literally Trump takes a page from Putin's playbook. See that? The Republicans are calling us autocrats and tyrants. Their entire shtick is Trump is pooty poo. Like, that's it. It's just politics, I guess.
But if they can persuade enough people that, oh, everybody does it, then they hope to at least muddy the waters. They undoubtedly are aware Americans are deeply concerned with Donald Trump's anti-democratic plans, his statements about terminating the Constitution, his intention to eviscerate the civil service, and so much more, weaponize the Justice Department, and he is trying to muddy the waters.
All right, so everything that they say Trump is doing, they are doing. They say he's a tyrant. They're the ones who are prosecuting him 4 times and weaponizing the legal system against him. But that's how they cope with themselves and sell books and sell viewers on MSNBC and elsewhere. So we'll be here continuing to cover the Florida case as well. There will be more Trump filings, I'm sure, that resemble this as he continues to try to get access to more discovery and more information that the government is trying to hide from him. We'll be here continuing to cover, my friends. Thank you for subscribing. Thank you for visiting robertgovea.com to sign up for our daily newsletter. And so you can download the PDFs, all of which will be available there. And we'll look forward to seeing you there and back here on the next one.